All right, Michelle, can you confirm we are recording and streaming? Okay. Good morning. My name is Andrew French, Chair of the Kansas Corporation Commission, joined by my colleagues Commissioner Keene and Commissioner Keither. And I am now convening the settlement hearing in the matter of the application of the Empire District Electric Company doing business as Liberty for approval of the commission to make certain changes in its charges for electric service, docket number 26 EPDE 180 RTS. We will start with the entries of appearance, and I will begin with Counsel for Liberty.
Good morning, Commission. James G. Flaherty, Ottawa, Kansas, appearing on behalf of the applicant, the Empire District Electric Company, doing business as Liberty.
All right, good morning. For CURB.
May it please the Commission, Joseph A. Strap, Consumer Counsel, along with attorneys Todd Love, John Racy, and David Cohen on behalf of the Citizens Utility Ratepayer Board, or CURB.
CURB is well represented. Panel of attorneys. And for KCC staff.
Good morning, Commissioners. Madison Hain is entering appearance on behalf of Commission staff and the public generally.
Good morning, Ms. Hain. All right, we will now move to notice of this proceeding. Does staff have a recommendation regarding notice?
Yes. Staff recommends a finding that notice was proper. KSA 77518 mandates that notice of a hearing conducted pursuant to the Kansas Administrative Procedure Act shall be issued to all parties at least 10 days prior to the hearing. On February 10th, 2026, the Commission issued an order setting the procedural schedule in this docket, which designated June 22nd through June 24, 2026 at 10 a.m. as the date and time of this evidentiary hearing, and set the Commission's first floor hearing room as the place for this hearing. This order was served on all parties to the case. On June 18th, 2026, the Commission issued an order granting the joint motion of the parties seeking to convert that evidentiary hearing into a one-day settlement hearing to be held on June 23rd at 10 a.m. And this order was served on all parties to the case. Therefore, staff recommends a finding that notice was proper.
All right, are there any objections to such a finding?
No objection.
Hearing none, the commission will find that notice is proper and the commission has jurisdiction over this proceeding at this time and place. As far as preliminary matters, I understand the parties wish to admit all the pre-filed testimony into the record. Ms. Hain, is it your intention to make that motion?
That's right, yes. Staff respectfully moves that the Commission accept all pre-filed direct testimony, cross-answering testimony, rebuttal testimony, settlement testimony, and all exhibits filed by all parties in this docket to be admitted into the record of the matter.
I understand that was an agreed motion, but just pausing here to make sure there's no objection.
No objection.
Hearing none, the motion as made by Ms. Hain will be approved and all the reference documents are admitted. Are there any other preliminary matters the commission needs to address before the hearing? All right, hearing none. We will move to the procedure for the hearing. First, I understand that Liberty will be making an opening statement, followed by brief opening statements from CURB and staff. And after opening statements, we will follow the order of witnesses agreed to in the pre-hearing conference. I understand at the pre-hearing conference, the parties indicated they do not anticipate to request to make closing statements. So we will begin with opening statements. Mr. Flaherty, on behalf of Liberty, I believe the floor is yours.
Thank you, Your Honor. And I'd ask Michelle if she could put up our PowerPoint presentation, and you should have received hard copies of those this morning.
morning for not getting anything going.
Michelle, do you have the PowerPoint or would you like us to forward it to you? Okay. All right. Are you ready to proceed then? Okay. All right, Mr. Flaherty, it looks like we have it up. If the clicker doesn't work, I think you could verbally cue Michelle to advance the slides,
Okay, yeah. Great.
but
Okay,
please
good morning.
proceed.
Good morning again. The purpose of this hearing is for the parties to submit their testimony that supports the unanimous settlement agreement that was filed by the parties in this case. As you will probably notice if you've skimmed through the hard copy of the PowerPoint presentation that was provided to you at the beginning of this hearing, my presentation will be very similar to the presentations that I've made you sit through during the extraordinary run of rate case filings that you and I have been involved in over the last 18-month period, where you've had all 5 investor-owned utilities that operate in Kansas submit their rate case request to you to decide. The fact that all 5 utilities have filed rate cases in the last 18 months is not a coincidence or a one-off fluke in scheduling alignment. Now, the fact that all 5 utilities have filed rate cases in the last 18 months is because as the country is celebrating its 250th birthday this year, the utility industries more or less are nearing their 125th year of operations. Investments are being made to make sure older equipment is replaced and strengthened so that those utilities can continue to provide safe, reliable, and resilient service to their customers. As you know, utilities can't begin recovering their investments until the new plant goes into service and until a rate case like this one is filed seeking permission to begin recovering those investments. Thus, the reason for all 5 utilities filing rate cases in the last 18-month period. Empire is no different than those other 4 utilities. As you likely gleaned by reviewing Empire's application in this case, replacing a substation in Baxter Springs, Kansas that was over 70 years old, or making other significant investments in its distribution system, and including the cost of the 3 wind projects in rates that have been providing capacity and energy for the last 5 years, are beneficial to Kansas customers and should be included in rates, and were really the big drivers in this rate case filing. Everyone acknowledges the economic challenges in today's environment, but the investments included in this rate case are and will continue to provide real value to Empire's customers. For example, the revenues generated from the sale of power from the wind projects into the SPP marketplace will offset much of the cost of that investment. They will provide a necessary hedge against higher natural gas prices in the future, as well as help Empire meet reliability and requirements. As noted later on slide 7 of this presentation, Liberty did take steps in its original filing, in this case, to mitigate the impact of the requested rate increase amid current economic conditions. These included phase-in in implementing the rates, extending the amortization periods associated with the regulatory assets being requested in this case, recommending a rate of return on equity at the lower end of the consultant's range, maintaining existing depreciation rates, and adopting a measured rate design structure. Collectively, these measures smooth bill impacts over time, enhance rate stability, and provide a reasonable transition for customers. In no uncertain terms, the company recognized the potential customer impact and proactively incorporated multiple measures to moderate that impact. So the purpose of my opening statement is mostly the same as in those other rate cases you've heard in the last 18 months. I want to walk you through the terms contained in the settlement that are being presented to you for your review and approval. I do want to take one detour to my usual process of walking through the terms of the settlement and introducing the company's witness who will be answering your questions about the terms of the settlement. The reason for the detour is that there was one issue among all the other typical rate case issues that seemed to unfortunately dominate all other issues in this rate case and admittedly had an impact on the settlement process, in my opinion. It's worth saying a few words about that issue, and Ms. Emery, the company's witness who is supporting the settlement, can certainly answer any questions the commissioners might have regarding this issue. The issue that I'm referring to was why was the amount of the requested rate increase high as compared to past rate cases filed by Empire. There was also the related issue of whether Empire should be financially penalized because the rate increase was high as compared to past rate cases filed by Empire, seemingly because Empire should have filed 2 rate cases over the past 4 years instead of just the 1 rate case that it did to have lessened the impact to customers. You can check the KCC records for the past 25 years, or if you're like me, you can relive those last 8 Empire rate cases that were filed and decided since 2001. And you will see that a typical rate increase request for Empire over the last 25 years has been between $4 million and $6.5 million, and usually was the result of Empire adding a new power generator or generators to its generation fleet. And while the cost of those new generators were significant, because Empire operates what is referred to as an integrated utility system, and I'll go into some detail in explaining what that actually means. It uses that integrated utility system to serve customers in 4 different states. And because of that, the cost of those new generators are spread across those 4 states based upon a specific allocation formula that takes into account in part coincidental peak usage served in each state. For example, roughly 5% of Empire's coincidental peak usage is in Kansas, and therefore a new generation facility at the time it goes online, like for example, the State Line combined cycle natural gas fired generation unit, would cost Kansas customers only about 5% of the total cost of the new generation unit. Next slide, please, Michelle. Let's see. Yep, I am. Thanks. So let me explain what I mean when I refer to the fact that Empire operates an integrated utility system. Slide 3 shows the counties in each of the 4 states in which Empire provides electric service to customers. Roughly speaking, about 88% of Empire's coincident peak usage is in Missouri, and therefore they're allocated 88%. As I previously indicated, about 5% of the coincidental peak usage is in Kansas, and the other 7% or so are split fairly evenly between Oklahoma and Arkansas. As you can see from the map on slide 3, Empire serves customers in 2 counties in Kansas, in the southeast corner of Kansas, Cherokee County, where it serves retail customers, and then a wholesale customer in the neighboring Labette County. When I say that Empire operates an integrated utility system, I mean that even though the State Line combined cycle natural gas generation unit is located in Missouri, it serves all of Empire's customers in all 4 states because Empire operates an integrated system. So Kansas receives about 5% of the cost of that plant because it receives about 5% of the power from that plant, or in today's SPP world, about 5% of the revenues generated by that plant on sales into the SPP market. Just because the State Line plant is located in Missouri doesn't mean that Missouri receives 100% of the cost of the plant. Again, because of the integrated nature of Empire's utility system, all 4 states pay their fair share portion of that State Line plant. Let me give you one more example of how the integrated utility system works. And this is the same with the Riverton generation units. The Riverton generation units are located in Riverton, Kansas, along the banks of the Spring River. Fun fact about the Spring River, it's one of few rivers in the United States that flow from south to north. The first unit at Riverton was placed in service in 1905. You will see in the settlement agreement a reference to Riverton Units 13 and 14 that will soon be placed in service at that historical site. The generation units located in Riverton, Kansas, just like the state line units located in Missouri, provide service to all of Empire's customers in all of its states because, again, Empire operates an integrated utility system. Just because the Riverton, Kansas units are located in Kansas doesn't mean the cost of those units get assigned 100% of Kansas. So in this case, Empire is back asking for approval of the 3 wind projects that were placed in operation in 2021. As you will recall from the abbreviated rate case, 2 of the wind projects making up 300 megawatts in total are located in Missouri, and 1 of the wind projects making up 300 megawatts is located in Neosho County, Kansas. Like State Line, Riverton, and Empire's other generation units, the total cost of those 3 wind projects was significant, but if the settlement is approved, then Kansas customers will be paying for about 5% of the cost of those 3 wind projects, less depreciation expense on those plants that has occurred the last 5 years since those plants have been in operation. That 5% is still a significant amount to be paid by Kansas customers, but is much less than if Kansas customers paid 100% of the Neosho County wind project because it was located in Kansas. There are clearly benefits to Empire operating an integrated utility system. The reason why I spent so much time on explaining how Empire operates an integrated utility system and how that is beneficial for Kansas customers because the cost of the generation units, even those located in Kansas, are paid for by customers in all 4 states, is that there are certain costs and investments that relate to the plant that only serve customers in specific states and therefore are assigned to only those customers located in that specific state. One of those costs or investments relate to substations that only serve customers in the state where that substation is located. For example, the investment cost in a distribution substation to serve customers in Branson, Missouri are not charged to Kansas customers. In this rate case, Empire is asking to recover its investment in a relatively new distribution substation to serve customers in the Baxter Springs, Kansas area. It is replacing a distribution substation that had been in operation for over 70 years. The cost of constructing that new distribution system was significant, and because it only serves customers in Kansas, 100% of that cost was allocated to Kansas. Empire's also made significant investments in other distribution facilities that are also assigned 100% in Kansas. Slide 4 is a photo of the Neosho wind farm located in Neosho County, Kansas. It began commercial operation on May 1st, 2021. Of the revised $14.1 million rate increase request in this rate case, investment and costs, operating costs, relating to the 3 projects are about $4.5 million of that $14.1 million. That is comparable to the range of rate increases requested by Empire in its last rate cases, 8 rate cases over the past 25 years. Slide 5 is a photo of the relatively new Baxter Springs, Kansas distribution substation. It began commercial operation around January of 2021. So that means Empire's Kansas customers have been receiving the full benefit and use of that new substation without Empire recovering any costs relating to that substation. Of the revised $14.1 million rate increase request in this rate case, investment and costs relating to the Baxter Springs, Kansas distribution substation was about $1 million, and other distribution investments, including the rate case, made up another $2.2 million of the rate increase request. The issue raised by staff in this case was that Empire should have filed 2 rate cases instead of 1 rate case over the last 4-year period in order to reduce the amount of the rate request, and that its failure to do so should be financially penalized by the commission. If you turn to slide 6, slide 6 is a timeline of the period between when new base rates went into effect from the abbreviated rate case on July 1st of 2022, which was actually a reduction in base rates, if you recall, because of the Asbury plant. And then August 1st of 2027, when phase 2, the new rates will take effect if the commission approves the settlement, in this case as requested by the parties. The purpose of showing you this timeline is to show whether it would have been made any significant difference to customers if Empire would have filed 2 rate cases instead of 1 rate case during that 4-year period as originally suggested by staff in this case. Taking a closer look at the timeline on slide 6, new base rates went into effect on July 21st of 2022 as a result of the abbreviated rate case. As this commission knows, it frowns on utilities filing a rate case without having experienced at least one 12-month period in which new rates are in place. That way, the utility has a 12-month test year that shows revenues under the new rates before asking to increase rates again. Of course, as indicated by Mr. Grady in his direct testimony in this case, the staff's real preference is that a utility stay out between 3 to 5 years in between rate cases in order to use regulatory lag to promote utility efficiencies. This timeline just assumes that the use of the 12-month period with new rates in effect in order to avoid what used to be called pancake rates. And pancake rates, a pancake rate case is where the utility asks for a new rate case or a new rate increase while another rate case is still pending before the utility commission, thus the stacking or pancaking of the rate increases. And assuming a period of time to close the books after the test year and prepare a rate case filing, the earliest a rate case could have been filed would have been around January to March of 2024, with new rates from that rate case going into effect 8 months later in December of 2024. Again, assuming the avoidance of a pancake rate case filing and using a test year where the new rates starting in January of 2025 are in effect, the earliest a second rate case could have been filed would have been around July 1st of 2026 or next month, with new rates from that rate case filing going into effect in March of 2027. That is really not that much different than what will occur in this rate case if the settlement is approved or if Empire's proposal had been approved.
Hey, Mr.
What-
Flaherty,
yes.
I'm sorry for
Yeah, no
interrupting, just for clarity, and you're probably getting there, but it was not clear to me when I saw this timeline. This is just intended to show both the proposal in this case, but also to blend in hypothetical or illustrative additional rate cases.
Correct.
Okay.
Yes, you follow that correctly.
Okay.
Thanks. So one thing that is for certain, and one thing that is different from that 2 rate case filing scenario, and I think this was recognized by Mr. Grady in his testimony in support of the settlement, is that Empire customers have not been harmed because their base rates have not increased, and they have been receiving the benefits of the investments made by Empire without having to pay for those investments. And as noted by all the parties in this case, and which really should go not unnoticed relating to this issue, is that Empire's base rates have either stayed the same or have decreased in the last 14 years. Basically, the same or decreased base rates have been in effect from 2012 through 2026. Empire's customers are among the few Kansas electric customers that have experienced that type of stability in rates, and again, should not be ignored in this case. Whether it be for the new Baxter Springs distribution substation, the other investments in the distribution system in Kansas, or the capacity from the 3 wind projects that Kansas customers have benefited from without having to pay for that capacity. Kansas customers have received the benefits relating to all of those investments without having to pay for those investments that have been made by Empire. Just one last point on this issue before walking you through the terms of the settlement. Slide 7, and I mentioned this earlier, shows all of the steps that were taken by Empire in its original filing in order to mitigate the higher than normal rate increase requested in this rate case. Those steps were significant. Those steps were discussed and coordinated in part after discussing this issue with staff and CURB and before this rate case was filed. And it's important to note, and you can ask each of the parties' witnesses that support the settlement questions, but the impact of those mitigation steps that are shown on this slide are included in the settlement, along with additional concessions that were made by Empire. Let me now turn to the terms of the settlement. And slide 8 indicates that the settlement before you today for review and approval is a unanimous settlement agreement. The settlement was agreed to by all the parties and was filed per the commission's scheduling order by the June 12, 2026 deadline. The settlement addresses all outstanding disputed issues raised in pre-filed testimony, and each party has filed testimony in support of the settlement. Charlotte Emery, who's the Senior Director of Rates and Regulatory Affairs for Liberty Central Region, filed testimony on behalf of Empire, and she is here to answer any questions you might have about the settlement. Ms. Emery participated in the settlement discussions and was the lead negotiator for the utility. The plan is for Ms. Emery to answer your questions today at the hearing, but in the event you have a question that would be better addressed to another witness, we have Mr. Tim Wilson, who is president of Liberty Central Electric, here in person to answer those questions. We also have Mr. Aaron Dole, Senior Director of Energy Strategy, who's also available to answer questions, and he appears virtually. Turning to the specific terms of the settlement, slide 10 lists the 10 primary terms covered by the settlement and are identified on this slide deck. Most of these terms are terms that you would see in a typical unanimous settlement agreement in a rate case, although there are some unique terms relating to this specific case. My plan is to walk you through each of the 10 terms in some detail. Slide 11 shows the first issue resolved by the parties. The parties agreed that the stipulated revenue increase in the revenue requirement would be $8.775 million, with half of that amount, $4.387 million, being collected in year 1 of the 2-year phase-in period beginning August 1st, 2026, and the full amount being collected in year 2 of the phase-in period beginning on August 1st, 2027. It is important to point out that the stipulated revenue increase will be offset by approximately $1.63 million, which is 50% of the benefits and revenues derived from the 3 wind projects being placed in rates in year 1 of the phase-in, and approximately $3.27 million, which is 100% of the wind project revenues and benefits in year 2 of the phase-in period, as well in subsequent years. Slide 12 provides a comparison of the stipulated increase to revenues included in the settlement and the increase to revenues recommended by Empire staff and CURB in this case. It also shows that the net revenue increase, after taking into account for Empire and staff the revenues and benefits from the wind projects. CURB opposed the wind projects in its recommendation, but has agreed in this settlement to include the wind projects. Slide 12, as shown on slide 12, Empire's recommended increase in revenues was revised to $14.10 million in its rebuttal testimony and schedules, taking into account the revenues and benefits from the wind projects that will be provided to customers through the ECA of approximately $3.27 million. The net increase to customers would have been $10.83 million. Staff recommended increase in revenues was $8.55 million, taking into account the approximately $3.27 million in revenues and benefits from the wind projects. The net increase to customers was $5.28 million. And CURB's recommended increase in revenues was $6.56 million. Those recommendations are compared to the $8.775 million increase stipulated to by the parties in the settlement, with a net amount taking into account the $3.27 million in wind project revenues, $5.50 million in year two of the 2-year phase-in period. Turning to slide 13 and finishing up on issue 1, the stipulated revenue requirement. As you can see from that comparison, the gross increase or net increase in year 2 of the phase-in period and years thereafter are essentially based upon the recommendation made by the KCC staff in this case, and it falls within the low end and the high end of the various recommendations made in this case. When the commission combines that fact with the actual evidence presented in this rate case by the pre-filed testimony and schedules of 32 expert accountants, economists, and engineers with extensive experience and expertise, which was entered into the record earlier this morning in this hearing, the stipulated revenue requirement is clearly supported by substantial competent evidence and is therefore reasonable. One other point on this, and that is the amount of discovery through the issuance by staff and CURB of nearly 500 data requests and the company's response and updated responses and supplemental responses to those nearly 500 data requests over the past 6-month period. From Empire's perspective, this case has been fully audited and reviewed based upon the discovery process that took place as part of this rate case. By the way, Empire wants to thank the staff and CURB for their professionalism in this rate case. Slide 14 sets forth the provisions in the parties agreed to relating to the phase-in of the increase in base rates. First, the parties agreed that the annual increase in base rates of $8.775 million would be phased in over 2 one-year periods beginning August 1st, 2026. In the first period, 50% of the increase, or $4.387 million, would take effect. In the second period, the remaining 50% of the increase would take effect beginning on August 1st, 2027. Second, the parties agreed that Empire shall be allowed to defer and accumulate as a regulatory asset and recover in its next general rate case 100% of the difference between the amount of the annual rate increase in base rates and the first period phase-in amount. Third, the parties agreed that Empire would not be allowed to recover any carrying charges on the deferred and accumulated amount. There may be some clarification regarding this provision that is needed. It is Empire's understanding that the deferred amount that will be established as a regulatory asset under the second provision that is in paragraph 9 of the settlement will be included in Empire's rate base, and that the carrying charge will be set at 0. I think Mr. Grady in his testimony indicates that it is not to be included in rate base. And so that issue probably needs to be clarified and may be an issue that comes up in the next rate case. Finally, the parties agreed that the amortization period of the regulatory asset Empire used to recover the deferred and accumulated revenue amount shall be determined by the commissions in Empire's next general rate case. Now that staff witness Grady has testified that customers were not harmed and in fact received the benefit of Empire's actions, Empire will be requesting a minimum amortization period of the regulatory asset in its next general rate case. Slide 15 addresses the third issue agreed to by the parties in the settlement, and that issue was whether Empire's investment and O&M costs relating to the three wind projects should be included in rates. In their file positions, Empire and staff supported the inclusion and Kerr opposed the inclusion of the wind projects in rates. The parties were able to reach agreement that Empire should be allowed to recover the investment and cost of its wind projects in its cost of service. In addition, the parties agreed that Empire should be authorized to account for the wind project investments in accordance with the regulatory accounting treatment as outlined by Mr. Evans in his direct testimony at pages 5 and 8, in which he refers to that as the look-through accounting treatment that Empire has received in its other states. Finally, with respect to the wind projects, the parties agreed that 50% of the revenues and benefits associated with the wind project shall flow through to customers under Empire's ECA tariff in the first year of the phase-in period, and 100% of the revenues and benefits shall flow through to customers thereafter, to be administered as proposed by Mr. Dahl in his direct testimony at pages 8 through 18, where he identifies both the revenues and the benefits that will be flowed through the ECA. Slide 16, in the next couple of slides, starting with slide 16, identify certain policy and accounting issues that were necessary for the parties to specifically include in the settlement in order for the parties and the commission to know how those issues were decided for rate making purposes for the period in between this rate case decision and the next rate case decision, and for having the specific starting point for other issues for the next rate case filing. Slide 16 discusses one of those items, which is what the parties agreed to in relation to what Empire could use as a pre-tax rate of return for purposes of calculating AFDUC, PISA, and CWIP filings that are made in between when this rate case is decided and when the next rate case is decided. The parties agreed that a pre-tax rate of return of 8% should be used, and because it is a pre-tax rate of return, the parties agreed that should any tax rate changes occur between now and the next Empire rate case decision, the pre-tax rate of return in the settlement shall be adjusted to reflect the changes in the tax rates. For what it is worth, the pre-tax rate of return in the settlement is below the pre-tax rate of returns that were recently approved by this commission for the other four investor-owned utilities operating in Kansas. And Ms. Emery discusses that point in her testimony in support of the settlement. Slide 17 includes the other provisions agreed to by the parties with respect to the pre-tax rate of return included in the settlement. And Ms. Emery also discusses the significance of these provisions from the company's perspective. In the settlement, the parties made it clear that they agreed to the use of the indicated overall rate of return solely for the purpose outlined in the settlement. The parties further agreed that nothing in the settlement constituted an agreement by the parties to the capital structure, cost of debt, or cost of equity presented in this case by the other parties. Finally, the parties agreed the settlement would not prevent the parties from challenging such proposals in future rate cases. Slide 18 addresses the agreement reached by the parties relating to depreciation rates. If you recall earlier, I indicated that one of the steps that Empire elected to take to mitigate the rate impact was to propose to use existing depreciation rates set by the commission back in its last general rate case in 2018, instead of the depreciation rates supported by the updated depreciation study conducted on behalf of the company for purposes of this rate case. This mitigation step reduced the overall annual increase by about $1.5 million. In the settlement, the parties agreed to Empire's proposal to maintain existing depreciation rates. To the extent that the commission determined that Empire needed a waiver from the commission's order that requires utilities to file depreciation studies at least once every 5 years, the parties agreed that the commission should grant that waiver. There were 4 New categories or accounts that did not have depreciation rates under the depreciation rates approved in Empire's 2018 rate case. And with respect to those four plan accounts, which related to the SAP Enterprise Platform, the wind projects, FERC 898 accounts, and AMI meters, the parties agreed to use the depreciation rates recommended by Empire. And the depreciation rates agreed to by the parties are included in Appendix 1 to the settlement. Slide 19 sets forth the parties' agreement on property taxes and pension and OPEB expenses and trackers. The parties agreed on the amount of property taxes included in base rates. This is one of those items that is necessary to call out in the settlement because it will be used as the basis for the property tax balance used for purposes of future annual AVTS filings for the period the new rates are applicable. With respect to pension and OPEB expenses and trackers, the parties agreed that the commission should authorize the continuation of a tracker mechanism for pension and OPEB O&M expenses similar to what is in place for other investor-owned utilities that operate in Kansas. Parties also agreed on the amount of those expenses in rates for purposes of the tracker mechanism. Slide 20, at the top of slide 20 are additional pension and OPEB expense provisions that were agreed to by the parties in the settlement. At the bottom of slide 20 is the provision in the settlement where the parties agreed to a list of regulatory assets and liabilities and the applicable amortization periods for Empire. A schedule of the list of those regulatory assets and liabilities and their respective amortization periods is attached as Appendix 2 to the settlement. Slide 21, there are provisions in the settlement that address certain issues relating to class cost of service studies and rate design proposals presented by each of the parties in this rate case. Schedule showing the billing determinants and the new rates for each class of customers that were agreed to by the parties is attached as Appendix 3 to the settlement. A table showing the weather normal and sensitivity factors agreed to by the parties is attached as Appendix 4 to the settlement. The parties were able to reach agreement on how the rate increase should be allocated among the respective classes of customers, excluding lighting, and that is included on slide 22 and as part of paragraph 12.c of the settlement. Slide 23 discusses issue number 6, which relates to the calculation of the reversal of excess ADIT. There was no opposition to Empire's request to move from a ARAM method to an RSGM method to calculate the reversal of excess ADIT in order to comply with tax normalization requirements. And so the parties were able to agree to the request made by Empire in this rate case, along with agreeing to the RSGM amortization period identified in the settlement and in the slide 23. Slide 24 identifies issue number 7 that relates to Empire's request to cancel certain tariffs that are no longer necessary or were no longer being used by the company and customers, and to change the name of the average payment plan tariffs. There was no opposition to these changes, and so the parties were able to agree, and those were included in the settlement. Issue number 8, which is slide 25. Currently, 2 investor-owned utilities in Kansas have approved transaction fee-free programs in place. The other 3 do not. Empire, as part of this rate case, requested approval of its transaction fee-free program because it has seen more and more of its customers to use these payment options that currently have a transaction fee associated with them. Empire also indicated that it seems that the use of these other options is more efficient and would benefit not only those customers that take advantage of those options, but also those customers that don't, because overall reduction in cost in order to use the programs that are in place. The parties agreed. Staff and CURB opposed this transaction free program request by Empire. And so the parties agreed in the settlement that Empire would not go forward with its transaction-free program. Slide 26, issue number 9 relates to the parties' agreement to allow Empire to use an alternative rate-making mechanism to having, as opposed to having to file a full-blown rate case, such as the use of a surcharge mechanism to recover investment and cost in new generation in order to lessen the impact of future rate increases on customers. Riverton 13 and 14, which are scheduled to be placed in service later this year, are relatively two small 25 megawatt units. The plan would be for Empire to file an application with the commission to begin recovering costs associated with those two new plants after they've been placed in service through a surcharge. What is referred to as the ERAS generation unit is the slide says combined cycle. That needs to be changed to a simple cycle natural gas unit included in Empire's Missouri IRP filing. Empire has received a certificate of convenience and necessity from the Missouri Commission for authority to construct and own that unit, which is currently scheduled to go into service around 2030. Empire would like the ability to recover CWIP related to that plant. The parties agreed in the settlement that in order to lessen the impact of future rate increases on customers, that staff and CURB would not categorically oppose Empire's request to use these alternative rate-making mechanisms. And I would note, and I believe Mr. Grady noted it in his direct testimony, the staff has been supportive of alternative rate-making mechanisms for Empire in the past with respect to more than one of Empire's generation units. And Ms. Emery also discusses this provision in her testimony in support of the settlement and the importance of this provision from Empire's perspective. Slide 27 sets forth the 10th issue, which is related to the modification of the procedural schedule in this case. Slide 28 shows the rate impact of the agreement among the parties to phase in the stipulated rate increase and to account for the revenues and benefits customers will receive from the operation of the wind projects that will offset the increase in base rates. As you can see in this slide, in year one of the phase-in period, the average increase will be $14.73 per month for residential customer using 1,000 kilowatt hours per month. This is an increase of 11%. In year two of the phase-in period, the average increase will be $12.98 per month. This is an increase of 9% for a total of the entire amount of 20.5%. I think Mr. Unruh discusses this in his testimony as well, and I think both Empire and the staff are agreement on these rate impacts on residential customers. Slide 29 shows the three factors the commission considers when reviewing a proposed settlement. I've already mentioned a few of these things. The settlement is obviously supported by substantial competent evidence because the amount of the rate increase falls at the lower end of the proposed recommendations. As a result, you also have all the testimony from 32 expert witnesses that support that level of increase. Therefore, the rates are just and reasonable. And the settlement also is in the public interest because it's agreed to by all the parties, all who represented themselves, their various interests during the settlement. Slide 30, let me conclude by indicating that Ms. Emery is here this morning to answer any questions you have about the rate increase in the settlement. Mr. Wilson is also here in case you want to ask him any questions. And if you have any questions relating to the wind projects that can't be answered sufficiently by Ms. Emery or Mr. Wilson, we have Mr. Dahl available to answer those questions. Empire would respectfully request that the commission issue an order approving the unanimous settlement agreement that is before you for consideration with the new rates for year one of the 2-year phase-in period to be effective on August 1st, 2026. Thank you.
All right. Thank you, Mr. Flaherty. We will now move to Curb for its opening statement. Mr. Astrab.
Thank you, Chair French. Good morning, Commissioners. First and foremost, thank you for the opportunity to be here today to present on the unanimous settlement agreement in this case. Liberty did a very good and thorough job of reviewing the terms of the agreement, so I'm going to focus on Curb's perspective in this case and what our overall view and the impacts on the customers were and how we wanted to deal with that. We will have our consultant, Mark Garrett, available today to answer any questions regarding our review of the case and the considerations that led Curb to joining in this unanimous settlement agreement. I think Mark Garrett said it best in his direct testimony when he categorized the initial request in this case as rate shock upon rate shock upon rate shock. The numbers speak for themselves. 90% increase over current rates is a level that Kansas has not seen in a rate case for quite some time. And so that was the perspective that we walked into with this rate case when talking beforehand with the company, with staff about how to address it going forward. And so we recognize this collaborative approach to deal with this massive rate increase for Liberty's customers. Although we recognize that there was no precise moment or action that we could attribute to how we got here today, we did conclude that the best way to move forward is with the understanding that each party should have to share in this burden. And so this $8.775 million revenue increase, inclusive of the wind assets, is a meaningful reduction to the initial increase requested by the company. And so that went a long way in getting Curb to sign on to this agreement to bring down this rate shock situation for customers. And going towards this idea of the sharing of the burden, you saw the terms from Mr. Flaherty's presentation regarding the treatment of the regulatory asset and the consideration of carrying costs there and the sharing of the burden between the company and the ratepayers. Additionally, the wind assets are being included, so Kansas customers will be paying for those on their bills, and now they'll be sharing the benefits and the savings associated with those assets for the first year. Again, a dividing of the burdens and the benefits here to recognize that this is how we can move forward and how we can start looking at affordability in cases going forward as well. Additionally, the use of a two-part phase-in will provide rate relief for customers and giving them time and the opportunity to prepare for this new normal in their rates as they start ratcheting up over the years. And so this gives ratepayers time to really evaluate their situations and start making plans now for the rate increases in the future. And considering the relatively smaller population of Liberty's customers based in Kansas and the economic status of the community down there, the cost to maintain the electrical system can and will have a disparate impact on a community. We saw that at the public hearing while we're there talking to the residents of that community and seeing firsthand kind of their experiences and their feelings about these rate increases. And we're definitely cognizant of that at Curb. And although this agreement represents an appreciable reduction from the company's request, there will still be people who will face new struggles under these rates. And so the terms in this agreement to deal with alternative rate making mechanisms to essentially address these costs upfront and to spread out the increases as a way to hopefully prepare people for these pressures and to reduce the burden of rate shock in these situations. However, these new mechanisms don't necessarily alleviate the need to make the investments in aging system, new growth. Those kind of considerations aren't necessarily being addressed, but it does provide some relief in the rate making process to do it at a more paced, a more monitored pace as we go forward there. And in light of all of that, Curb believes that the terms of this settlement agreement do represent a fair and reasonable conclusion or outcome based on the record of evidence provided. And so we are joining the other parties today for these terms because we believe that it will provide some measure of relief for customers in light of the company's needs today. Thank you.
Thank you, Mr. Astrab. Ms. Hain for KCC staff.
Good morning. Thank you. As counsel for Empire and Curb have just described, all parties in this docket are unanimous regarding their request that the commission approve the settlement agreement, which represents a complete resolution of the issues presented in this docket. Staff believes that this settlement agreement is supported by substantial competent evidence in the record. 14 staff witnesses, 14 Empire witnesses, and 4 Curb witnesses have filed direct testimony in this docket, with many of these witnesses also filing cross-answering, rebuttal, and settlement testimony. These are witnesses who represent varying interests, and they were able to reach a complete and satisfactory agreement based on substantial evidence in the record. Staff further believes that approval of the terms of the settlement agreement will result in just and reasonable rates. The agreed upon revenue requirement of $8.775 million adequately balances the interests of Empire's investors with the interests of its ratepayers without jeopardizing Empire's ability to provide efficient and sufficient electric service. In addition, the settlement agreement supports a 2-year phase-in for rates in order to address customer affordability concerns. The terms of the settlement agreement also adequately eliminate inequity between present and future ratepayers. The shorter 2-year phase-in helps to balance customer affordability of the rate increase while ensuring that future ratepayers are not heavily impacted by the recovery of deferred revenues. Finally, staff believes that approval of the settlement agreement is in the public interest because it appropriately reduces the amount of the company's revenue increase to an approximate value that was supported by staff's filed position. And it generally enables Empire to recover costs from used and useful investments under appropriate regulatory mechanisms. The terms of this settlement agreement provide Empire with a pathway to request an alternative rate-making mechanism and to propose a surcharge to recover generation-associated capital investments with plant additions at Riverton 13 and 14 and the ARES unit. These types of regulatory mechanisms can lessen the impact of future rate increases, can delay the filing and costs associated with a full rate review, and can lessen the regulatory lag that Empire is exposed to for generation-related capital investments. Although staff initially recommended that the commission deny Empire the use of a deferred revenue regulatory asset during the phase-in of its rates, staff is confident that the terms of this settlement agreement strike the correct balance between affordability concerns and the appropriate recovery of rates which Empire is entitled to. Staff witnesses Chad Unrein and Justin Grady are available today to answer any questions that the commissioners have about staff's position. Thank you.
All right, thank you, Ms. Hain. We have concluded opening statements and we are ready for the examination of witnesses. But before we do that, I would like to take a short 5-minute break, give everybody a bio break. So we will break until, where's the clock? I've got 11:08 right now. We will reconvene at 11:15 to begin the examination of witnesses. So we are off the record and in recess until 11:15. That's great. Michelle, are you ready whenever we are ready to begin? All right, this is Chair French. We are back on the record in this settlement hearing in docket number 26 EPDE 0180 RTS. And we are ready for the examination of witnesses. Liberty, you may call your first witness.
Thank you, Your Honor. Liberty would call Charlotte Emery.
All right, Ms. Emery, I'll have you move to the witness stand, and before you sit down, I will have you stand and raise your right hand for me. I'm going to swear you in since we don't have our court reporter with us today. Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth? All right, thank you. Please be seated. You may proceed, Mr. Flaherty.
Thank you, Your Honor. Can you please state your name and business address for the record?
Sure. Charlotte Emery, and it's 602 South Joplin Avenue in Joplin, Missouri.
And Ms. Emery, who are you employed by?
I am employed by Liberty Services Corp.
And what position do you hold there?
I'm the Senior Director of Rates and Regulatory Affairs.
And in that capacity, have you been authorized to testify on behalf of the company today in support of the settlement?
Yes, I have.
Okay. It's my understanding that you have one correction to make to the testimony in support of the settlement. Could you identify what that correction is?
Sure. So in my settlement testimony on page 11, if you go to line 18, I have indicated that the ERAS unit is a combined cycle, and that needs to be corrected to read a simple cycle.
With that, Your Honor, I'd ask that, I believe all the testimony has been referred into the record, so I would tender Ms. Emery for questions from the commission.
And we will accept that clarification to her filed testimony.
Thank you.
All right. I believe the parties have all waived cross-examination since this is a unanimous settlement. So we will move directly to questions from the commissioners. And I will begin with Commissioner Keen. If you have questions of this witness.
Yes, thank you. Good morning, Ms. Emery.
Good morning.
Just a few questions from me. Let me look at this somewhat holistically and starting my questioning. We had an original base rate increase request by the company of 15.8 million. We have a unanimous settlement agreement base rate increase of 8.77 million, rounding off. A difference of about a little over 7 million, or roughly 44, by my calculation, roughly 44% less than the amount that was originally requested by the company. So my question in light of that is this: from your perspective, given the significance of this difference, what is it about the settlement agreement that assuages concerns the company may have about the effect of this reduction?
So the original request was 15.8 million in the company's direct testimony. We later revised that through our rebuttal testimony, bringing it down to 14.1.
I follow that, yeah.
Yeah. And so to the difference essentially between the 14.1 and the 8.775, it's a negotiated amount amongst the parties. All of us came in with certainly differing views on what was needed. One of the primary, there was probably two primary items contained within the settlement from the company's perspective that was very important for us to be able to reach an agreement on that would result in just and reasonable rates. And that had to do with the deferred regulatory asset for the phase-in of the rate increase. And then the second item would be the alternative rate making mechanism. That was really important for the company to get support. We recognize the increase that we proposed in our direct testimony was substantial. And there was reasons that led to that. And we believe that the alternative rate making mechanism is a step forward in helping us hopefully not commit the same issues with rate impacts in the future.
Could you elaborate on that just a bit for me?
Sure, on the rate impact for
Yeah.
the future, sure. So one of the significant increases, and it was mentioned earlier, had to do with the wind projects. And so that was just shy of $5 million worth of the rate increase. And so having this alternative rate making item would allow us to be able to go in and file a surcharge. So we can request the ERAS unit and the Riverton 13 and 14 in between rate cases. And hopefully that would allow the company to be able to recover the costs needed for those investments. But it's also designed to help customers be able to gradually see the impact in their rates versus all at once through a base rate increase.
Okay, I appreciate your response to that question. Within the context of this alternative rate making mechanism, you indicate, at least as I read your testimony in support of the settlement agreement, you're indicating here that you had some concerns about the rate of return of 8%, and juxtapose that against some prior rate cases. And I think you opined that it was that aspect of the settlement agreement, when considered with other aspects of the agreement, to set the stage for a future rate case on an accelerated timeline. If you can embellish what you mean by that for the open record here this morning, I'd appreciate that. Kind of tell us, if you will, what you're anticipating or is going to be the essence and potential effect of that on ratepayers and the company.
Sure. So maybe in a little broader sense about the entire settlement, a little bit broader than the 8% rate of return pre-tax, is there are some real expenses and costs to serve customers that we believe through the 8.775 million increase, it didn't reflect that. And so we believe we will need to come in a shorter time frame than what would typically would have Empire coming in. And that's, essentially since I've been at Empire, and I started in 2016, we filed a case in 2016, a case in 2019, 18 timeframe, and then another abbreviated case in 21. And then we filed this case in 25. So, it has 3 to so many years apart from each one of those. But I would say, as part of this indication, I made it quite clear during the settlement negotiations that the Empire would need to consider coming in earlier, just to shore up that fact that the rates currently are not reflecting the true cost of service.
All right, thank you for that. When you are part of the process of vetting internally, in anticipation of the filing of a rate increase, can you give me some insight into the specificity specifically about how it is you go about trying to assess or anticipate the effect that rate increase is going to have upon your customers?
Yeah. So one of the primary things that the company will go through is first to assess whether or not a rate increase is needed. And that's generally guided off of the concept that are you actually earning the last authorized rate of return that your commission outlined for you? And so you could go in and assess that. And, and I believe Mr. Wilson indicated in his direct testimony that Empire was close to less than 2% of its rate of return at the time of our test year and our filing. And so, if you take that 2.2% it was just a little less than 2%. Compare that to the authorized was around 7. That's roughly 5%. And you can tell that that's going to be a fairly significant rate increase because in order for you to get back up to that level, it's going to require a sizable rate increase.
Originally, as I understand it, the company was requesting basically a 10% ROE. Is that correct?
Yes, that's correct.
As the settlement agreement worked through, there is no specificity with respect to the ROE other than what we've already generally ascribed the 8% to. Is that correct?
Correct. There wasn't a assignment from parties of what that represented. Correct.
Capital structure was not specifically addressed.
Correct.
So I guess my question is, and I don't mean to be this, I'm going to be as direct as I can, and I don't intend to be in any fashion, even inadvertently rude, but I'm going to be very direct. As a monopoly operating within a service territory exclusive to you for the purpose of providing your services, how is it that you determine what you believe to be is a fair ROE?
Yeah, that's a valid question. So we as a company, we actually engaged a consultant, an expert witness that goes in. She had significant experience across the whole industry, not just in Kansas, not just in Missouri, but she's an expert that goes in and did a full evaluation of what the proper rate of return on equity should be. We actually, in working with her, her recommendations based on the analytics that she did, her recommendation was actually higher than the 10%. We were on the lower end, but that's one of the items that the company, we knew the rate increase was significant. And as a result of that, I had conversations with her that I think we needed to bring and propose a ROE that was at the low end of her recommendation based on all of the analytics that she actually performed.
If I can press you just a little bit further on this topic, what do you think are the important components that would provide justification for an ROE of that amount?
Of the 10%.
Yes, the higher
amount. The 10%. Yeah. So I would say the justification is the company in providing service to our customers should have the opportunity to at least earn a reasonable rate of return. And when you go out and you look in her testimony provides it a lot more detail than what I'm going to be able to explain to you. But she essentially says, and she runs it through several analytics and different steps of analysis of what the market actually expects. And so keep in mind that the utility is comprised of equity and it's comprised of debt. So we have investors that are commonly coming in and they're like, oh, do we invest in this company at Empire or do we go down the street and go invest at Google? And so we have to be able to give an appeal and a return on equity that would want them to entice them to invest in our utility.
I appreciate the candor of that response. And as a backdrop here, I want to say this on the record too. In performing my duties and responsibilities as a commissioner, I'm concerned with the balancing proposition that we're confronted with. We're balancing the interest of keeping rates as low as we possibly can for ratepayers while providing the utilities that are jurisdictional to us with a fair rate of return. So it was in the context of that balancing proposition that I asked that question. Yeah. One other question, if I could ask this. I have reviewed the public comments that were filed in this case. We had roughly 43 comments, 42 were opposed, 1 was neutral. I don't think there's anything unusual about that. Nobody likes rate increases. I think that's fair to say. The thing that struck me, however, were that two nonprofits. One is the Cherokee County Ambulance Association, and the other is Spring River Mental Health and Wellness. These both submitted letters that, in essence, stated that the requested rate increase would hinder their ability to provide services to their community and to the county. And that really struck me because I think there appears to be, to me, a great deal of credibility in that concern. So if you could address for me, what is your take on the public comments generally and in with more specificity, the concerns of these two nonprofits?
Yeah. So one, I would just say thank you for them taking the time to send in a comment and participating in the whole process. I mean, we certainly need to hear and want to hear from our customers. And so, you know, I would have to say, you know, I participate in Empire's rate cases in other jurisdictions as well. So in Missouri, Arkansas, Oklahoma. And the concern about affordability it's real. I often sit and hear customers ask, how am I going to afford afford to pay your bill and pay my medical, pay my rent? And so the company is sensitive to that. I don't, and I've shared this with a few folks, that it's not a pleasure on the company side to go in and request a rate increase that's just shy of 100%. There was absolutely no joy when I was filling that application out. I knew it was going to be tough, and we honestly tried everything we could. We knew that those investments were prudent. There wasn't any finding of imprudence of the investments that we made. But they were necessary because the ambulance, the caregivers inside of Cherokee County, when they go to turn their lights on, they're going to want that light to be able to be turned on when they need to serve their patient. And so it's our responsibility as their service providers to make sure that that's there as often as possible. And so I hear it. I really do appreciate the concern. And I think that's why the company found itself in a position where we agreed with the settlement as presented, and because we felt like at the end of the day, it did result in just and reasonable rates, and it also properly tried to address the impact that some of our customers are going to feel from it.
Thank you very much. I appreciate the candor of your responses and your indulgence of my questions as well. I have no further questions.
Thank you.
All right, Commissioner Keither, any questions of this witness?
I too read the comments that were sent in, and they were consistent. That's for sure. My concern is, and maybe I've just missed it, but the policy of the company in ensuring that the ratepayers can make their payments. What kind of programs do you have in place for them? Because in the comments, it was pretty clear that the customers don't think they have access to a process to be able to pay their bills.
Yeah, so in Southeast Kansas, we do have the community action agencies that can come in and help some of our most vulnerable customers. So we certainly have that availability and for the customers on that effect. And then I would also say, in addition to that, that 2-year phase in, we spoke about it. It's I think it was 11% that first year, that 9% that second year. Mm-hmm. And I'm not trying to minimize it because, to be honest, I grew up in a family where the 11% and the 9% were significant. And so I don't take it lightly when we say it, because I know that really is going to come out of the wallets of some very hardworking individuals. But we did try our very best to help mitigate the impact to our customers.
So the answer to the question is the company itself does not have a program in place.
Correct. We
Have
do
you
not.
considered that?
We often consider it, yes, and especially in the light of rising affordability issues. Yeah.
That's quite a concern, yeah, because you say they're choosing to pay their electric bill or their rent, whatever. I mean, it's a problem. I would think that would be something if you could to really think about establishing, because I know certainly Evergy has one, because I'm part of it. I mean, I pay my bill that way, and it makes a difference, and a lot. So I would think that that'd be something for the company to think about.
Yeah, I appreciate your feedback.
Thank you. Okay.
All right, good morning.
Morning.
All right, I've got two lines of questioning, and one of them you may defer to Mr. Wilson. We'll see once we get there. But the first one I want to start with is I think it's a continuation of a conversation you were having with Commissioner Keen, and he asked you about, there were some references in your settlement testimony, largely pages 11 and 12, but I don't believe you need to go there. He asked you about some statements in that testimony that indicated that there would be pressure on Empire to file another rate proceeding maybe sooner than you'd hoped. And the answer you gave on the stand was 100% consistent with what you put on paper. You identified two things. You identified the cost of capital result that is built into the settlement, not an explicit ROE, but the cost of capital element. And you identified ongoing expenses that you don't believe are fully captured in the revenue requirement. And that's what you said at page 11 of your testimony. You said there are, quote, certain ongoing expenses that are not or that are currently being incurred to serve customers. I guess my question is that both of those issues were issues in this case, and they are part of the settlement. And so that they're not new issues. Is it the position of the company that you would just like to take another bite at the apple and file another case and see if you get a different result in that next case? Or is there, or am I wrong? Are these issues that were not addressed in this case?
No, you're correct. They are issues in the case, and maybe one of the best examples I can give you relates to payroll, and the approach that. And I don't think this rate case is any different than any other rate case. You have the company who proposes a approach on what the appropriate way to calculate a cost is. And then you have the differing parties have their view of what those costs should be. And so I will just give you the view of the company when it comes to a significant cost, which is payroll expenses. How the company views that the level of payroll expense that should be included in the cost of service should be based off of the head count at the end of the pro forma period. And so in this case, it was December 31st of 2025. We would propose that you take the head count, annualize that out for what you expect the payroll cost to be for that given year. And that approach is different than what some of the other parties proposed. And so it's those types of differences that I would say in this particular case, there was a pretty good gap of real hard expenses that the company needs to be able to recover because we're incurring them. We pay out payroll twice a month for the most part, and those are real costs that's being incurred. I hope that it helps.
It does. I guess I'm still struggling with, I mean, that's no different than any other issue in the case. The parties are going to have different opinions on how to normalize or update a cost in a case, and then ultimately you have a settlement. It just strikes me that if you boil it down, the statement seems to be we don't like the settlement, even though we're telling you it results in just and reasonable rates. And so we're going to ask you to look at these issues again very soon. Is that fair?
So I would say a valuable lesson that was learned from myself speaking personally, and I would say a broader to the company, is we don't want to find ourselves in a position again where we're asking for almost 100% rate increase, correct? And nobody benefits from anything like that. So if we wait your typical maybe 3 to 5 years, with the level of inflation, with the level of investments that's going to likely occur, we wouldn't want to find ourselves in a position where we have to do that again. And so we need to make sure that level of, if it gets there, the level of under earning doesn't grow to that size.
Well, that is a great segue to my other line of questioning. And it is that process of making sure you don't get to this place. And I guess I know that you've only been in your current position since 2022, but you've been a rates analyst. You were a rates analyst before that at Empire starting in 2016. Is that correct?
Yeah.
And so, it's okay if you say I wasn't in some of these meetings, but I want to explore, I guess, what got us to this case today. I know that it's been framed as we didn't file enough rate cases, but maybe we could dig a little deeper than that. I know Commissioner Keene asked you what causes you to choose to file a rate case, knowing that it's going to have an impact on customers. And you gave a correct answer, which is, we look at our earned rate of return, and if it is below a reasonable rate of return, that will cause us to file a rate case. And I understand that from a regulatory theory perspective. But I guess I want to go farther back, more into the strategic planning, capital spending plans, long-term capital spending plans, plans for upgraded operations equipment, things that might affect your O&M in addition to capital investments. So all those things holistically in the long term, I can imagine there's a long list of things that every utility would like to do, and probably every one of those things is prudent. So can you tell me a little bit about the process at Empire, and it's okay if you need to defer this, but when you're having those discussions, say 10 years ago, and I recognize that's when you started at Empire, what do those discussions look like internally when choosing which projects to pursue? And this is a run-on sentence. And when is the evaluation done of what the rate impacts will be given those spending plans? Or is that available to you in the discussion of which projects to pursue?
Yeah, I would probably defer most of those questions to Mr. Wilson. I'm not necessarily involved in the ins and outs of the capital outlay.
I understand. You're regulatory. You're on the back end. Well, I will just defer that to Mr. Wilson. Let me see if I had anything else. Oh, I do have one. It is just a technical clarification, and I want to make sure I understand it. And this relates to the regulatory asset of the phased-in revenues. So as I understand the settlement, it says that those missing revenues will be allowed to be deferred and accumulated as a regulatory asset. And then I believe the settlement says, and Liberty will be allowed to recover those in its next rate case. That's a little different to me than a lot of times I see a regulatory asset where we allow it to be accumulated, but we don't make the decision of recovery until the next rate case. Can you just confirm for me that was the intent of the settlement, that it would tie the future commission's hands that those revenues would be recovered.
Correct. That the company needed that language in order for us, I think I had mentioned to Commissioner Keen earlier that there was two really big sticking points for us related to the deferred regulatory asset account. And without some certain language related to the recoverability of that deferred revenue account, our external auditors would not allow that to be recorded on our income statement, balance sheet type of financial statements. And so that would get us in some issues with that. So that's correct.
Oh, thank you. Appreciate that. All right. Before I allow for redirect, any additional commissioner questions? I'm seeing none. Any redirect necessary?
No.
Okay. All right. With that, Ms. Emery, we appreciate your testimony today, and you may step down.
Thank you.
Thank you so much. All right, Liberty, you may call your next witness.
Yes, Liberty would call Mr. Timothy Wilson.
Okay, Mr. Wilson, before you sit down, I'll have you do the same routine as Ms. Emery. If you would please raise your right hand for me. Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth? Thank you.
Please state your name and business address for the record.
Timothy N. Wilson, 602 South Joplin Avenue.
And who is your employer?
Liberty Utility Service Corp.
And what is your position with that company?
I am currently the Central Region President of Electric.
And in that capacity, did you file direct and rebuttal testimony in this case?
Yes.
Your Honor, at this time, I'd tender Mr. Wilson for questions from the commission.
All right, thank you. We will begin again with Commissioner Keen. Do you have questions of this witness?
I do have a couple. Good morning, Mr. Wilson.
Good morning.
I read through your rebuttal testimony. I don't believe you provided subsequent testimony in support of the settlement agreement. Is that correct?
Correct.
Okay. So if I can reflect, I don't mean this question to be unfair, but that kind of sets an overview of where I'm headed here in this question. As I understood one aspect of your rebuttal testimony, and I don't mean to characterize this unfairly, and if you think I do, you can correct me, certainly do. But I think, I believe you were concerned about the recommendation by staff and by CURB to deny Liberty the recovery of deferred revenue or carrying costs during this 3-year phase-in period, and you described it as being fundamentally unfair. Yet doesn't that appear to be one of the final terms you agreed to in the settlement agreement? Am I mischaracterizing?
Not exactly. So the final terms actually allowed us to have a regulatory asset
Okay.
to defer those costs and then amortize them out at a later period. And the initial stance by staff was that, for example, and during your phase-in, if it were 2 of 8 million, for example, you would never get the other 6 back. And that's where it was characterized as unfair.
Okay, that helps. Thank you. I'm going to ask for your take on one of the first questions that I asked of Ms. Emery. I'd like to have your perspective on it. The question is simply this: given the significant difference between the original rate request and the rate increase that it would be permitted by the settlement agreement if the commission were to approve it, it is, given the adjustment to 14.8 million, that's not a 44% decrease. It's more like a 41% if my math's semi-correct. So given that, anyway, from your perspective, given the significance of this difference, what is it about the settlement agreement that assuages concerns the company may have about the effect of this reduction?
I think it does a couple of things. It does hit on all those comments that we got from our customers. We do listen. I was at the local public hearings. We heard it. Affordability is an issue. the agreement also allowed us to phase in rates. That is something that's important to us. And so there's puts and takes anytime there's a settlement agreement. And even though there's the delta that you mentioned, we were also able to get 50% of the wind revenues in year one that helped bridge that gap. But ultimately, it was a combination of those things that really got us to where we thought we could be to come to an agreement.
Okay. No further questions.
All right. Commissioner Keith, are any questions? Okay. We're zipping along here, but I'm going to slow us down. All right, Mr. Wilson, we'll just start with the line of questioning I was starting to pursue with Ms. Emery. So you got a bit of a preview. Again, I'm going to apologize. This is probably a long question, but I hope you'll get my gist. So when you are going through long-term strategic planning processes, say a 5 or 10-year capital spending projection, maybe long-term discussions on operational expenses, large expenses or investments that are going to change your cost structure. Can you tell me about how those discussions take place and whether there is a direct consideration of how and when those will impact either the revenue requirement, rates, customer bills over time?
Yeah, so I'll try to tackle it in two parts, and you might have to remind me of the second one. But you may be familiar with the integrated resource plan that we do in Missouri. It's triennial filing. It takes a look at how to serve your customers based upon a multitude of sensitivity analysis, whether it be load, whether it be natural gas prices, any other rules or regulations. And it takes a look at the net present value of revenue requirement over a 20-year period to establish those major generation items. So for example, the wind farms that we proposed in the abbreviated case in 2021 would have been the result of that type of net present value of revenue requirement planning.
Do you do any equivalent process internally for O&M investments or distribution investments? I mean, for instance, I know there was a large IT customer service piece as part of this case. There was obviously the substation, which I think was about $1 million of the revenue requirement impact here.
It was.
Do you do an equivalent process for all those types of cost increases and investments as you do for the IRP for generation?
I would say we always take a look at affordability. In some cases, we have a capital expenditure management policy that describes how we go about selecting projects. We have the obligation to serve. So in some instances, for example, with the distribution substation that's 161 kV and has 4 12 kV circuits, that's all going to be in Kansas. And so when you take a look at affordability, you know that's going to hit you. At the same time, there are other projects that we have pulled out because of affordability. I can name 2 specifically that whenever we're doing our capital planning, it's like, okay, this is in Kansas. This is going to be jurisdiction specific. We've already got the distribution going on. We already didn't get wind and rates in the 2021 abbreviated case. We had that coupled with, I hear you guys had a new IT system too. This system touched every little facet possible. And so when you take a look at that, we said from an affordability perspective, there's 2 projects that we still need to do that we've took out of the planning horizon. One is a reconductoring of some line down by Hallowell, Kansas. Okay. Very, very old line, maybe older than those substations. Don't quote me on that yet. And then if you're familiar with Galena, Kansas, there's that historic Main Street, and on the east and west sides of Main Street, in the alleyways, we have a reconductor. We need to reconductor some lines pretty bad there. But from an affordability perspective, those are the types of things that we look at. And some of those are just mandated and required. But if it's discretionary, we'll do a business case for it, and it'll have to carry its own ROR and see if it cash flows for our customers. So for example, one that we did was a cooling water intake structure that we're currently constructing at State Line Combined Cycle. Right now, we spend about $1 million a year in O&M there. We can spend a few $1 million there to get our own water supply that offsets that $1 million. And so that's one where it would be discretionary, but it pays for itself.
So it sounds like there is some process to consider revenue requirement impacts or bill impacts even before these decisions are made, whether it's an investment decision or you know, operational maintenance cost decision. Was there a point, you know, I know we're dealing with sort of a jumble of decisions that took place over maybe 10 or 15 years.
Yes, sir.
Was there a point when you were making decisions for the investments and cost structure changes that led to this case where it became apparent that, you know, rate base might be doubling and that the
Yes.
customer impacts would be severe? And can you tell me what the internal conversations were at that point?
Yes, so it all goes back. I'll give a little bit of history, and if I get to going too long, just say, that's enough. We were talking about early in the opening statements where you would like to have 4 to 5 years between rate cases, sometimes 3. Well, if you look back in our history, we filed in 2012, we filed in 2016, we filed in 2018, we filed in 2021, and we filed in 2025. So just from a macro level, you would say that things shouldn't be pancaking, right? That's about normal. Well, what really began this, and you guys are familiar with this, is the 2021 abbreviated wind case, when we were trying to get our wind assets into rate base and commensurately so get the winds, the fuel savings into the energy cost adjustment. And because of the nature of that case was an abbreviated case, it only took into consideration that all parties agreed to 3 things: the wind assets, the Asbury accounting treatment for the retirement of it, and then for non-growth plant investments and the associated depreciation. So what that didn't catch, it also had a 12-month end of June 30 test year for those items. What it didn't catch was the investment of that substation that we just talked about. It was completed in January of 2021. So at the time, I don't think the parties realized it. I certainly didn't, but even more important, whenever it became evident based upon the record of the witnesses and other discussions that the recommendation was going to be that to not have the wind in rates, even though we acknowledged that we could need it for capacity in the future, but not at that point in time. That's when the company made the decision. I wasn't part of the decision, but this is what it is that they made the decision to make a motion to pull the wind portion of that abbreviated case. Contained within that motion, reserved the right, if the commission approved it, to come back and make another run at it. With that decision and the resulting base rate decrease, that is when I noticed it, and the company started making plans to figure out moving forward, what we were going to do. So this is a combination, at least in my mind, of aging infrastructure. I think if you saw in Eric Babbitt's, I think it's EB1, it's not just the distribution substation there. We had $6 million of customer extensions. We had another $6 million of aging poles. So it's a combination in my mind of aging infrastructure, a once in a generation distribution substation, combined with not getting the wind in rates for all those years, led us to where we got to today. And to be honest with you, I know we're not proud of it, of where we are, but that's really how we got here today.
No, I appreciate the detail. So I guess I guess I want to give you an opportunity for a very direct answer here, because you talked about that you have a process to look at what bill impacts are going to be and what affordability is going to be. given the projects that you elect to pursue. And I think you said that there actually are some projects on the list that you think would be prudent to pursue, but they just couldn't make the cut because of that affordability concern. So would it be your testimony that everything that was pursued for this case was absolutely necessary, could not be spaced out? This was the minimum that had to be done.
I would say yes. From a technical perspective, what we didn't touch on is a lot of the generation projects that we did. We upgraded the CT at 2-1 and 2-2. We got significant O&M savings there from fuel savings, as well as additional capacity that we know we really, really, really need. State Line Unit 1, we had to do a rotor replacement, right? Again, it was broken. We had to do it. So some could say, well, you could have just not fixed it. We can't operate that way. That's that some people sometimes miss the other side of the equation on our generation units. They also generate revenue. And so it's not just cost. And so those are some of the things that were also in this case that I believe are the large chunks that were absolutely necessary, and that we shouldn't be in a similar position moving forward.
So let's extend this a little into the future. We're definitely hearing the message, Ms. Emery's testimony, that another rate case is very likely in our near future. I know when I look at the testimony, it says the average residential bill after the 2-year phase in is going to be, I think, in the 163 region. You correct me if I'm wrong there. This isn't in the record, but in the KCC's annual reports, we calculate an average bill for all the utilities, and that 163 will be materially higher than the next highest utility that we regulate. And so if there's another rate case on top of that, it starts to get quite a bit higher than the other utilities we regulate. To what degree will Liberty's management be trying to benchmark themselves and stay competitive, and looking at those cost decisions moving forward on things that are going to impact the future rate cases, to not let this get away from all of us? To what extent are you going to consider bill impacts in the future?
Right. So very appropriate question. And for correction, it was, I think, $163.08. After year 2, it's $27.71 in bill impact. But I would say the appropriate benchmark for a utility serving 9,913 customers in Southeast Kansas probably isn't Evergy. It may not even be other utilities as well. So what we would try to benchmark it to is our Missouri customer base. And when you go into the 3rd year of the phase-in rates in Missouri, this is commensurate with that. And in fact, check me if I'm wrong, a little bit below where we're at in Missouri. And honestly, you're comparing 9,900 to 168,000 customers. And so I'm actually, when you take that into consideration, I'm proud of where we ended up.
Yeah, so I think that's a really fair answer, and it actually dovetails with my last question here. I totally, in my head, I'm thinking about this issue that you've laid out, which is this jurisdictional issue you have. You've got 9,900 customers in Kansas, and when you have a large investment that like the substation investment or some other distribution investments that can't be spread over a larger customer base, that results in a very outsized or lumpy impact on that very small customer base. I know in testimony and in past proceedings, we've also talked about just simple things like rate case expense, which for a large utility is probably just a rounding error in their rates, but it can be material when you're trying to recover it from a very small jurisdictional set of customers. You know, this is a little bit of an uncomfortable question, but I think it's an obvious question to ask, and that is, has management at Liberty had discussions about acquisitions, changes in ownership structure that could lessen the impacts of investments on that very small customer base in those two counties?
I will say I have not been involved in any merger acquisitions. I totally understand and appreciate the spreading of fixed costs over more customers. That's why I would love to get some economic development people on our economic development rider. We have someone on the MOCAN Economic Development Board. But no, not to my knowledge do I see that.
Okay, thank you. All right, I believe that's all I have right now. Any additional questions, Commissioner Keen?
Yes, Mr. Wilson, if I could. I'm looking back on, we need not bring it up, but it's Mr. Flaherty's slide number 3, which shows your service territories within 4 states.
Mm-hmm.
So you're juggling, I'd use the juggling metaphor, already tiptoed down that lane, but you're juggling a lot of regulatory balls, so to speak, here with 4 different jurisdictions that I'm going to guess can be, depending upon the issues, quite dissimilar one from the other. Is that fair?
I would say there are certain areas where they're dissimilar, yes.
Probably more similarities than dissimilarities, generally.
Generally.
And that is a terrible overgeneralization. So I'm sorry that I asked you that question. That's kind of a lead up to me asking this. As I understand from Mr. Flaherty's opening statement, roughly 88% of your customers are in Missouri, 5% in Kansas, and roughly 7% split between Oklahoma and Arkansas. Pretty
yes.
Close. Given these 4 jurisdictions, have you had and given the fact that, as I understand, some of your major operational facilities, you're using assets that may be in any one of these 4 states to service the other 3.
Correct. Generation being specific to that. They would
Yes,
spread the cost
absolutely.
over all the jurisdictions, yes.
Sure, absolutely. And you've given some specific examples of that otherwise. Given that a backdrop, have you had an analogous issue to the one you've had in Kansas in any of the other 3 jurisdictions? That is, in terms of the timing or scope or scale of the rate increases?
No, I would say in that instance, they've been a little bit dissimilar. We got the wind and rates in Missouri and other jurisdictions. So I think, and then whenever you have a once in a generation asset in Missouri, you can spread it over 168,000 customers. So I think the size and scale, and then, where we all came to a conclusion from the abbreviated rate case is really dissimilar. And so I would say that.
One other question. It may seem to be a bit obscure, but I'm going to try to frame it in a way so it's less obscure. Given the fact that you are significantly a Missouri-based utility, more specifically, Southwest Missouri-based utility, electric utility. When you go about the process of preparing and revising your integrated resource plan, you take into consideration, I take it, the effect, current and prospective, of other energy resources that customers may have available to them.
Absolutely. That's a large part of the analysis. It's several volumes.
The question I have relates to another docket, and given the fact that you're from Southwest Missouri, I'm not going to ask you to opine about that docket. I'm not even going to identify it for you, but I'm going to, in very general terms, ask you this question. Given that analysis that you go through incidental to your integrated resource planning, alternative energy sources impact it may have on your planning processes. If you could just briefly tell me, how would you assess the adequacy of natural gas infrastructure and the availability of natural gas in Southwest Missouri to service customers?
I would say it's adequate today. If we were to have a huge load growth in Southwest Missouri, we would need to either go south and grab onto another pipeline or have Southern Star be an anchor tenant for a new Southern Star pipeline for expanded growth. So right now we have enough firm capacity through Southern Star to run our Riverton combined cycle unit and our State Line combined cycle unit. And then when they call on our other units, we'll be dual fuel. So I think we're adequate today, but if there's a lot of generation moving forward, there will need to be expansion of the natural gas pipeline.
In terms of a competitor to your electric, is natural gas a serious competitor with consumers in
Well,
Southwest Missouri?
I want to make sure that we're saying the same thing. When I'm talking natural gas availability, I'm talking for power generation facilities.
I understand
Okay.
that. That's why I kind of refined my
Okay.
question.
There are people with natural gas in Southwest Missouri, not much in Branson. I see them as potentially complementary. I have a lot of folks that heat with natural gas and cool with electricity. So I see them as complementary, at least in our neck of the woods.
Yeah. Okay, very good. Thank you for your indulgence with that question.
And I would like to make one quick clarification, Commissioner Keen. I'm a proud Kansas resident and customer. And so I just wanted to make sure that you realize that.
Thank you for noting that.
Yep.
No further questions.
I guess I don't know that this is apropos of anything, but you've piqued my curiosity. I know one of the issues with natural gas infrastructure during Winter Storm Uri was, you mentioned you all have firm gas, but I believe firm didn't mean so firm during that storm.
If you got the rest of the day, you ask the next guy the question, but I'll save you some time. And we were on the end of the pipeline and people didn't nominate adequate gas, but they burnt it and such that it lowered our natural gas pressure, and we weren't able to run our units while our load was still paying very high prices, and we had no ability to get revenue back at those high prices.
I mean, that's the reason I asked it, is that issue is still seared into my brain. Is
Yes.
that if you're at the end of the line, firm may not be firm. Do you feel better about that situation today, or is it still, the fundamentals are still kind of there? If people don't, if they don't take what they're nominating.
If people follow the rules, then yeah, I think we're fine. But if they don't, we could, I mean, they thought a once in a lifetime event, and then we had another storm the next year. But we didn't see, if I recall right, near as many of those issues in the subsequent storm.
Okay. All right. Any additional questions, Commissioner Keither? Commissioner Keen, you're finished. I don't believe I have anything else. Mr. Flaherty, do you have any redirect?
No redact.
All right. Well, Mr. Wilson, we thank you very much for your testimony. You may step down.
Thank you very much.
I think we are at 12:15. And we have 1, 2, 3 witnesses left. I'm inclined to just keep marching along and try to knock this out. Is there any objection from the parties if you end up eating lunch at 1:30 or later?
No problem for Kurt.
I'm not seeing anybody jumping up. Is that okay with you? You're okay? All right, we will keep moving then. Curb, you may call your next witness. Sorry, I'm a guy that likes to eat at noon. So, when I always feel like I need to check with people.
Thank you, Chair. I appreciate that. But at this time, though, Kerr would call Mark Garrett to the virtual stand, please. I think he's online currently.
All right, Mr. Garrett, if you could just say hi and we'll see if you show up.
Hello.
Great.
All right. Hello, Mr. Garrett. If you would please raise your right hand for me. Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
I do.
All right. Thank you. Please proceed, Mr. Astrab.
All right. Thank you, Chair. Mr. Garrett, can you tell us your name, please?
My name is Mark Garrett.
Thank you. And what is your occupation and business address?
I am the president of Garrett Group Consulting, Inc., and the business address is 4028 Oakdale Farm Circle, Edmond, Oklahoma.
All right. And are you the same Mark Garrett that caused to be filed on behalf of Curb direct testimony on May 6th, 2026, cross-answering testimony on May 20th, 2026, and settlement testimony on June 17th of 2026?
Yes, I am.
Thank you. And have you had the opportunity to review that testimony before appearing here today?
Yes,
And as you are here today, do you have any edits or corrections to make to any of that testimony?
I do not.
All right. And if I were to ask you all those same questions in those documents, would those answers be the same or substantially similar?
They would.
All right. At this time, commissioners, I would tender the witness for questions.
All right, again, the parties have waived cross-examination, so we go directly to commissioner questions. And I'll start with Commissioner Keen. Do you have any questions for this witness?
I do have a couple. Good afternoon, Mr. Garrett.
Good afternoon.
I have one principal question that has two sources of origin. When I look at your direct testimony and at your cross-answering testimony, in both instances, through your testimony, Curb is recommending that the wind projects not be included in Liberty's rate base. And if I'm paraphrasing you correctly in your cross-answering testimony, that was because you believed that the wind projects were not shown to provide a benefit to customers and should not be included in the rate base. Yet that issue is resolved by including them in the rate base within the purview of the settlement agreement. Have you changed your position on that issue?
Well, I think it's a compromise to include the wind projects. I still believe that they're not yet providing a benefit. The cost is about $4.5 million. The savings is about 3.2 million, which is, so there's a net cost of about 1.3 million. But that's because of where gas prices are. And if gas prices increase, the savings will increase and there will be a net benefit from the projects. That is likely to happen over the next few years as we add load around the country. Is unfortunately will probably drive the prices of gas up. And so the wind at some point may be a real benefit to have on the system. So I think taking the longer view, there's good reason to include the wind. And as part of a overall negotiated settlement, it makes sense.
So I guess in answer to my question, you have modified your position on this? Or have you just explained it with more granularity?
Both.
No further questions. Thank you.
All right, Commissioner Keith, are any questions for this witness? No. Good afternoon, Mr. Garrett. This is Chair French. I didn't think I had any questions for you, but I want to explore that last line of questioning with Commissioner Keen just briefly. I totally understand the explanation you gave on why it may be reasonable for that to come in to rate base, for those wind assets to come into rate base now, but I guess I'm a little perplexed by the position, the initial position that those assets did not benefit customers. It seems that you're saying in your initial position that solely because a generation facility does not put downward pressure on rates, it would not be a benefit to customers. Is that is the position? If it does not reduce rates, then it is not a benefit to customers?
No, I wouldn't say solely, but that is a consideration. You know, when you look at wind projects going onto utility systems now, they typically provide a net benefit. In other words, they are cheaper than gas. And we know that's because of the tax benefits, but so they're being subsidized by taxpayers. But nevertheless, they're a better buy right now than natural gas. That's not true of these projects. They're still more costly, maybe because of the price that was initially paid. That's changing, you know, every month that the depreciation ticks off and lowers the cost of those assets. They're getting closer and closer to being a net benefit. Gas prices go up at all, there'll be a net benefit really quickly. So I think in the balance, it probably is a good idea, certainly not a bad idea, to include the wind projects in the rate base of the utility.
Yeah, I just wanted to make sure we had that conversation. I mean, the way I'm thinking about it is, yes, in Kansas in particular, we've had the luxury of building wind farms, and you know, they produce fuel cost savings and actually pay for themselves and put downward pressure on rates, where you know, a coal facility or a natural gas facility, obviously, you know, that's going to put upward pressure on rates. Now, the flip side of that is the accredited capacity that you get from a gas or coal facility is going to be much higher than the accredited capacity and reliability attributes you might get from a wind farm. So I guess, I mean, I see the trade-off there. I see what you're saying, that at least historically looking, utilities in Kansas have not made wind farm investments except for when they put downward pressure on rates. But there are maybe some new considerations and reasons why people would want to diversify moving into the future. So you know, if I've said anything incorrect there, correct me. I'm thinking out loud.
No, I totally agree with what you said. It's
very good.
Absolutely right.
I don't believe I have anything else. Any other questions from the other commissioners? All right, hearing none. We do thank you for your testimony, Mr. Garrett, and you may virtually step down.
Thank you so much. Appreciate it.
All right, we are now ready for staff. You may call your first witness.
Staff would call Chad Unrein to the stand.
All right, Mr. Unrein, if you will remain standing, raise your right hand. Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth? I do. All right, thank you.
Good afternoon. Would you please state your full name for the record?
Chad Unrein.
Who are you employed by and what is your title?
I work for the KCC, and I work for staff as a chief accounting and financial analysis.
Are you the same Mr. Unrein who filed direct testimony and settlement testimony in this docket?
Yes.
At this time, do you have any corrections or changes to make to your pre-filed testimony?
No.
Mr. Unrein's testimony has already been entered into the record, and so with that, I would tender the witness for commissioner questions.
All right, thank you. We will move to commissioner questions. Commissioner Keen, any questions of this witness?
Just a couple. Good afternoon, Chad.
Good afternoon.
My experience with your testimony in prior dockets, I think will be realized again. So I'm going to ask you a question that provides a lot of latitude for your response. In your perspective, from your perspective, what are the principal, most consequential elements of this docket and the settlement agreement that has ensued that demonstrate that it's supported by substantial competent evidence that results in just and reasonable rates and is in the public interest?
So generally, this docket includes the roll-in of the wind assets that were not rolled into rates in the 21-444 docket. The overall cost component of the net benefit and phase in that Empire kind of allowed for, early on, was to have discussion with parties on how to make it cost effective, given the amount of generation and infrastructure investment that they had spent over the previous periods. The wind assets are worth $444 million, and they had about a $4.5 million net impact on this case. And so essentially, we tried, as from staff's perspective, to get to a place that we believed that we were balancing the interest from utility rate to the ratepayers, yet providing some benefits back to Empire in kind of working through the settlement agreement with the parties. Generally, when it comes to the infrastructure investment, when Empire invested in its 3 wind projects, those were not needed from a capacity perspective, which is kind of where that docket kind of spun off. Subsequent even to that filing, there were quite a few things at SPP that had changed the planning resource margin and had kind of overall investments that they may not have necessarily contemplated in a capital plan. And so there were investments as a whole, which is the primary driver of the overall change in staff's recommendation. We got very, very close to the staff's filed position in this docket. There weren't too many concessions, and I think Empire took that, because we were at a lower revenue requirement, we were able to spread those costs over a 2-year phase-in instead of a 3-year phase-in. And so it also, in their effort to have deferred costs, a 2-year phase-in relied on less deferred costs to recover in a future case. And so staff was pretty adamant that the carrying charge that customers should pay is 0, which is kind of consistent with staff's policy, and it's more of a penalty arrangement of, making sure that a customer who is better off paying the full impact today, that they are able to still get value from the deferment over time. So subsequently, I think as a whole, the settlement agreement falls within the range of just and reasonable. It's based on tons of evidence in the record, and it also kind of is in the public interest for the rates that were set out in the settlement agreement.
Thank you. No further questions.
All right, Commissioner Keither.
I don't have any questions, but that was a question that entered into my mind too, so I appreciate the question and you answering it for him. Thanks.
Okay, good afternoon, Mr. Enrine. I've got just a couple cleanup questions. First, I'd like to explore the topic I was exploring with Ms. Emery I noted that in her settlement testimony, she mentioned on at least 2 occasions that there were some things that were going to pressure them to make a rate filing soon or sooner than they otherwise would like to. And it looks to me like those 2 issues are sort of the cost of capital and how that's applied in the revenue requirement here, even though it's an ROE is not explicitly defined. So cost of capital and I don't know, I have the quote written down, but it was certain operating expenses, I think was the other one. And it was my view that those seemed to be issues that were addressed in the settlement. And so the question I had was, why would that drive an immediate, next rate case? So I guess I would just like your opinion on whether those issues were addressed in the settlement, whether you think there are issues coming up that we are going to need to, new issues that we're going to need to decide. The only thing that I've identified is the regulatory asset at some point has to come up in a rate case for us to decide recovery of that or to allow recovery in rates. But is there anything else? Do you think those 2 issues need to be reexamined? What's your feedback on when you read that testimony?
No, I think they're addressed. I mean, they may not be addressed to the point that, all the parties see their own positioning and support for. A big thing in this particular docket is the capital structure differences in between the parties' overall costs. And so when there's that level of capital structure differences, it definitely kind of, has a general impact of where parties are going to land in the case. And so, if we look at the pre-tax ROR that came out, of the settlement that would apply for PISA, AFUDC, and CWIP, that pre-tax ROR is 8%. I did a quick comparison with the other utilities in Kansas, and they range from 8.37% all the way up to 8.97%. And I would say that part of the capital structure that puts Empire in lower on the list is that, at least from staff's opinion, we had a much higher debt ratio and equity ratio, when figuring out those parts of the case. And on whether all the costs were included, I think our payroll adjustment has been mentioned. We don't typically have only one set way to evaluate payroll. We look at it more holistically, try to figure out what normalized period makes sense. And I think from Empire's perspective, their December, both from the payroll aspect of it as their head count, if we use that entirely, normalize that across the remaining years, that is one way to do the analysis. However, there's been other cases where we've used year-end payroll, and others where we take a 3-month approach to our annualized value. And the other thing that I would say is probably what the company had a net impact on was the overall Kansas jurisdictional allocator. It looked like the December allocator was a little bit lower than what it had been in the test period, and staff updated that cost through the end of the year and used that end of the year number because it was the most known and measurable costs in perspective. So from our perspective, those 2 changes, the allocation ratio had a $1.2 million impact, And the difference between our payroll adjustment was probably 500K. So, you know, those are the real costs that Empire is talking about. And even when we are doing payroll, if we would annualize the cost as of the end of the year, you know, they're going to make future payroll adjustments and provide wages that may not be captured in rates. And so I think that's a little bit of color from what I think Empire has stated. But it is a primary driver of when do you file a new rate case, you know, and with the capital structure, we believe our capital structure position aligned with the commission's general capital structure policy. So from our standpoint, we really pushed to make sure that we could kind of capture what we saw were necessary costs and rate base, and still tried to give the customers a decent, you know, settlement that wouldn't result in, you know, pushing off too much deferred cost onto a next case and watch the whole thing start over.
So if I understood you correctly, and that was great additional color, as you said, if we were to start a brand new rate case 30 days from now, staff wouldn't anticipate taking a different position on capital structure. Staff wouldn't anticipate taking a different position on payroll. I mean, maybe I'm generalizing since you mentioned payroll is pretty dynamic, workforce can be dynamic, but you wouldn't philosophically change you would probably take a consistent position in a future rate case.
Yeah, I mean, we'd have to look at the data really to make 100% certain that we would follow the same methodology. But you know, one of the things we are hopeful for is that, you know, in including staff's not opposing of an alternative rate making mechanism, I'm hopeful that we will be able to use those type of things in the future to kind of broaden, you know, out to where Empire's not waiting outside to come collect, or we end up with rate cases every 2 years, which ultimately gets passed on to 10,000 customers. So there's got to be a balancing there. We think the alternative rate making mechanisms are a good structure. And I think Justin Grady had kind of mentioned from staff that, you know, had we known about the generation and distribution outlay, we knew about the generation with the wind farm. But if we knew about the distribution outlay, we could have came in and created a surcharge or rider that would allow those costs to be passed on a more consistent basis. You know, because one, they can't recover it until, you know, they go through the rate case stuff, and then customers are ultimately getting some advantage of not having a rate case and a movement in base rates.
All right, thank you. The only other question I had is really it's a cleanup issue, and I don't know that you need to look at it, but maybe, I don't know if you have a copy of Empire's opening statement, but at page 14, Mr. Flaherty mentioned that he was talking about the regulatory asset, and I think he mentioned that the parties may not have a meeting of the mind on whether those revenue amounts or the assets that covers are included in rate base. Did you hear that?
Yeah, I mean, there's nothing in the settlement agreement that says, you know, this is how we're treating these assets. So to me, I think fundamentally we would take the approach, and you can talk to Justin being the next witness on the deferred cost perspective. But I think because we're not including carrying costs generally, to roll those into rate base, I think would be a little inconsistent because you would be, providing a rate of return. Now, if you're deferring it over a longer period of time, I don't think there's anything that's limiting the parties to make those arguments and still comply with the commission, record in the settlement.
Yeah, I'm just a simple lawyer trying to make sense of accounting schedules, but is there any practical impact of those investments either being in or out of rate base at the moment? I mean, we've set agreed rates. Those could be explicitly requested to be part of rate base in the next rate case. I mean, that it doesn't impact their depreciation level, or, I mean, is there any practical impact of having them in or out of rate base at the moment since we have agreed rates?
No, that would all be set up in that future case. And the deferred amount that's being recovered, right now it allows Empire to defer them, and the settlement agreement allows them to be collected in the next rates.
Okay.
Subject to the parties' kind of agreements or at least proposals for the commission.
Okay, thank you. I appreciate that. I don't have anything else. The commissioners looks like shaking of heads. So, Mr. Unrein, oh, wait. Any redirect from staff?
No, we don't have any redirect.
All right.
Thank you.
I've covered all my bases now. Mr. Unrein, you may step down. We thank you for your testimony. And staff, you may call your final witness. I'm glad we plowed through.
Staff calls Justin Grady to the stand.
Mr. Grady, please raise your right hand. Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please proceed.
Good afternoon, Mr. Grady.
Good afternoon.
Would you please state your full name for the record?
My name is Justin T. Grady.
Who are you employed by and what is your title?
I'm employed by the Kansas Corporation Commission as the Director of Utilities Division.
Are you the same Mr. Grady who filed direct testimony and settlement testimony in this docket?
Yes.
Do you have any corrections or changes to make to your pre-filed testimony at this time?
No.
Because Mr. Grady's testimony has already been entered into the record, I tender this witness for commissioner questions. Thank you.
Thank you. We will begin with Commissioner Keen again. Do you have questions of this witness?
Yes, thank you. Good afternoon, Mr. Grady.
Good afternoon.
As with Mr. Unrein, I'm going to give you a very general question and give you all the latitude you want to explain yourself or hang yourself, as the case may be. It's my perception that this case has undergone quite a metamorphosis from the initial filing time to now, through the settlement agreement process for sure, and all the compromises that are attendant that process. So my question to you is this: as we look at the settlement agreement, and as you, I believe, are trying to encourage the commission to approve the settlement agreement, what is there within the confines of that agreement in terms of kind of a topical outline, the biggest issues there that you believe serve to simultaneously protect ratepayers and provide adequate rate of return for the company?
So I would agree that the case, there's been some degree of movement, I don't know, some fluidity, I guess, with regard to some of the positions that we took in direct relative to what ultimately ended up in the settlement agreement. But there's also a lot of consistency. I mean, it's obvious, I think, and apparent, and I think indisputable that ultimately the revenue requirement that was included in the settlement agreement it's essentially staff's revised litigation position. It and that was really important to us. That was kind of like a line in the sand that we weren't going to cross in settlement discussions, to be frank. And I understand there's a difference of opinion in terms, especially by the company, in terms of whether, that is a adequately compensatory revenue requirement level or rate level. Ultimately, it came down to an evidence issue from our perspective. I mean, we updated a lot of costs. We updated the amortization period. I'm sorry, the allocation level. We updated the allocation level to the end of the year. You could look at those allocators and you could clearly see that might not have been the most representative allocation ratio viewed through the lens of history, right? Over the last 6, 7, 8, 10 years, it looked like maybe that might be too low of a number. But the problem is, we can't see, we don't know what the 2026 allocation levels are going to be. We're looking at a situation where, from our perspective, it was kind of uncertain exactly what the future would hold. But to be honest, we took a pretty aggressive position in this case because we were faced with the prospect of a request to double base rates, right? And so it was unusual, a little bit of unusual, that some of the positions that we took, because we take seriously, we think our job, and the courts have told us, right, the commission's job is to balance the interest between investors and customers. And so when faced with the prospect of a doubling of base rates, you probably have to be pretty aggressive in order to come out at the end of the day with a balanced position. That was ultimately sort of the philosophy that staff took going into this case. And ultimately, that's why we settled where we did, as close to our filed position. It wasn't personal. It wasn't, we weren't trying to be like vindictive or unfair. Our position was, there is evidentiary support. We can get on the witness stand and swear and affirm to the numbers that that we're recommending. And ultimately, if we're going to have a settlement in this case, it's basically going to be staff's filed position, or the commissioners are going to make the decision, right? And so, there was litigation risk, I'm sure, in some of those positions. But ultimately, we felt pretty good, that our case had a better than average chance of succeeding. And ultimately, because the end result rate increase was still so large, we just thought, this is where we're drawing the line in the sand. That payroll issue that came up before is an interesting one. I mean, Chad mentioned it. We were upfront about it. A person that we had do our payroll adjustment, Katie Figgs, has done a lot of them, probably 10 or more. And there's a lot of ambiguity. There's a lot of nuance and detail, complexity that goes into a payroll adjustment. One way to do it is to add up every employee on the books, say, okay, they're all going to continue to be employed for the next 365 days. And that's what you get to recover from payroll expense. Well, what Katie would tell you if she was sitting down here is, when she looked at the actual numbers that were hitting the books over the last 6 months, she was saying, hey, they're not running at a full level. There's ebb and flow. There's, employees come and they go. And she's saying, I think that would be too much. I think that would result in a payroll expense that's too high. So those are the kind of, details. And I know the company probably vehemently disagrees with that. They could point to, I'm sure, a case where Katie has actually annualized the full payroll expense at the end of the test year. I've done payroll adjustments myself in the last 24 years that took a similar approach. So, you know, there's ambiguity, or there's nuance, there's hues of gray in these positions. But I would say ultimately, you know, that's the sort of the overlay of the philosophy that we were evaluating when we looked at the case. Ultimately, the settlement is reasonable. I think it's compensatory. I think it's, but I don't know. And I don't know what the future holds. I don't know the next rate case, what the timing of it will be. I know that our position on capital structure and return on equity is likely not going to be much different, if at all. But Chad answered the question accurately, that we'll have to call it as we see it. You know, when the operating expense data comes in, if you get a year, 2 additional years of an allocator, that then that would become pretty clear that, well, maybe that year in 2025 number was an anomaly after all. And we might have to back off a little bit of our position on that. Well, that might be $1 million rate increase, but you know, we just weren't willing at the time, faced with the kind of request that was before the commission. We weren't willing to compromise on that issue at this time, when customers are facing the kind of increase they are in this case, right? The next case, it may very well be different. We'll be guided by the evidence as much as we can, and also sort of the overall circumstances. You know, the wind issue is also a big issue. We were in a position where we agreed with the company that, you know, this case, that those assets are providing benefit to customers today. Sure, they're not paying for themselves 100% through the revenue produced by the integrated marketplace, but there's not a power plant in Kansas that pays for itself 100% through the revenues from the integrated marketplace, right? It's a different world. The chair's question was astute in that historically, a lot of wind investments in Kansas have been viewed as energy resources. And so it is kind of appropriate to look at them just purely based on the fuel savings that they produce or not. But it's a different world today, in that suddenly we find ourselves capacity deficient in a lot of ways. And this utility needs those wind investments to meet its capacity requirements. And so that was an area that we did disagree with CURB. That wasn't, in our opinion, you know, quite holistic or comprehensive enough of a way to look at the issue. So, you know, on balance, I do think that you consider everything that, you know, holistically, you consider, you know, the case that they filed, the position that we took, the rebuttal testimony and everything else. I think it's a reasonable settlement agreement. Ultimately, I think it's a position that will allow customers to, I mean, obviously it's a little bit more expensive and rate shock-ish than we would prefer, right? Around a 10% rate increase in 1 year, and then coming right back with another one is not ideal. But it's, you know, those are the kind of rate increase levels that this commission has approved in the past, at least on a 1 year basis. And so I guess just relative to what customers were facing, and relative to other alternative options, I feel like it's the best we could do. And I feel like it will be palatable for customers. It's not great, but it's not terrible either. It's certainly a market improvement compared to what the company filed.
Well, I'm not too surprised to say that you've anticipated and answered the other question I was going to ask as well. Thank you for that. Appreciate the granularity and the frankness of your testimony. No further questions.
All right. Commissioner Keither, any questions for Mr. Grady?
No questions, but I appreciate what you had to say. It helps a lot.
Good afternoon, Mr. Gray.
Good afternoon.
I'm not sure if I have a question for you or not. But when I get you on the stand, I want to take the opportunity. So you heard, I assume, you were here, you heard my discussion with Mr. Wilson about sort of the process they may go through in, making long-term capital investment plans, long-term O&M changes, and trying to anticipate how that might impact rates. And so, I'll cut to the chase. I think it's pretty clear. I have a thought that, you can have a long list of prudent investments, and that still doesn't mean that it's prudent to undertake all of them all at once. And I think Mr. Wilson handled my questions well. It does sound like they are trying to space things out to some degree to mitigate that. But it also sounds like there's a lot more cost coming. I know staff has focused on, alternative rate making mechanisms, sort of a regulatory structure to not to prevent those cost increases, but to handle them in a more, measured fashion to avoid rate shock. But I still have this concern that, they may have the highest bills in the state very soon, and they are indicating a need to come back for at least one more increase plus what's anticipated in the alternative rate making mechanisms in the settlement. And so the other issue I broached with Mr. Wilson is I hate to even broach it because you and I talk a lot about not invading management discretion, and that is not something that I think this commission is terribly interested in. But I know I really hope that people are thinking strategically and creatively about how they solve challenges in the future, given some of the disadvantages that Empire may have as a very small jurisdictional utility. I guess I would just open it up for your thoughts and opinions on what needs to happen in the next few years. Would you hope that they are exploring some of those issues? Is it just your hope that they are more proactive in speaking with the regulatory staff here at the KCC on how they pace and seek to recover investments? What would you like to see to make sure that we do continue to see sufficient service at just and reasonable rates from Empire?
Yeah, well, thanks for not letting me off too easy. Yeah, I mean, it has been it's a historic challenge that is facing Empire and its customers, right? I mean, it's a unique situation. It's a utility that serves in an area of the state and that other, the Four Corners region of where it's at, where it's a multi-jurisdictional utility with 88% of its load in one state and the other 12% spread around the other three utilities, right? The other three states. That's not easy. It's probably not an enviable situation to be in. It's probably not a super attractive option or probably not a super appealing situation to be in either in terms of other utilities, right? I mean, I certainly wouldn't want to take on that kind of, you just think about from a benefit cost perspective, if another utility were to want to come in and say buy the three small pieces of Kansas, Arkansas, and Oklahoma, I mean, why would you want to do that, right? It's not ideal, certainly. I mean, I do appreciate Mr. Wilson's response, and I think it is appropriate and reasonable for us to consider as well that it's probably not the fairest or the best comparison to compare Empire's rates to Evergy's, right? It's not totally unfair to compare them to some of the other small cooperatives in that part of the state. That's the sort of thing that, you know, can be done, should probably be done. And I think it's also very fair to compare the rates that Empire Kansas pays to the rates that Empire Arkansas, Empire Oklahoma, and Empire Missouri pays. And so we had a lot of those same conversations with Empire when, you know, the first couple of meetings that we had where they told us that they were going to be requesting, you know, nearly 100% increase in base rates. I really was hopeful that there was a decimal point that was off somewhere, you know, and that wasn't going to be the reality we were facing. But ultimately that didn't end up being the case. But the second question was how once the shock sort of subsided, you know, my question was, how's this going to compare to your other jurisdictions, so the rate cases that you just completed? And their response was, it will be pretty close afterwards, right? So, I mean, it's a deeply unsatisfying answer in that I don't have a lot. I don't have a magic, you know, I don't have a tool in the toolkit that can solve all of the issues of a multi-jurisdictional utility with very small operations in 3 states. You know, it's sort of set up to inherently be less efficient, you know, especially from an administrative and general expense perspective. It's certainly not ideal. And, you know, the way that we've dealt with that over the years has been really thinking creatively and trying to use all of the tools in the tool chest from an alternative rate making perspective to try to help this utility avoid filing a full rate case, right? And that was, you know, if there's anything that I sort of remain in disagreement with this utilities management, is that even today, all of the discussion in their opening statement and in Mr. Wilson's testimony was about filing a rate case. But my testimony also mentioned the fact that we would have worked with them. We have a history of working with them, exploring alternative rate making mechanisms to begin to phase in those revenue requirement impacts when they're needed. For a long time, the only, you know, alternative rate making mechanism that, like, surcharge to recover capital investments, that CURB had ever agreed to was an Empire mechanism. And that's not a coincidence, right? It's because everybody recognizes that avoiding $200,000 worth of rate case expense for a utility with 10,000 customers is in the public interest. You know, you've got to recognize that. And so, I don't know, that's not a great answer that helps a lot, but it's a big part of the issue. You know, if we can avoid the costs and the time and the expense of a full general rate case, then at least we're doing what we can to help. And then, I mean, it's just going to be up to the management of this utility to manage it in terms of it. It's totally unacceptable, in my opinion, to get to a place where you have to come in and request to double your base rates, right? They have to be more on top of it. They have to manage it better than that. They have to understand where they are on a year-over-year basis. And if they feel like they're getting to a place where they're going to be facing that, have to come in and initiate conversations with staff and find a way around it. That was primarily my biggest issue in this case, and why I filed testimony in this case, you know, this rate case. And, you know, I think that they will do that going forward. I mean, the combination of a pre-tax rate of return that's lower than any other utility in the state of Kansas today, as well as this uncertainty around the timing of the recovery of the deferred revenue, as well as whether it gets a return or not. You know, this hasn't been, it's not like this rate, the result of this rate case has been exceptionally satisfying for the management of this utility, I'm sure, right? I think they got the message, and I think they'll do better.
Yeah, I appreciate that answer. I mean, I think, and it's very clear to me that even after this rate case, there's a challenge ahead for their management that, we would all prefer for a utility to have, healthy, rate headroom so that they can make investments and stay ahead of needed infrastructure upgrades. And it appears that in this case, to me, and you can correct me, but it looks like they're going to have to make difficult decisions for quite some time now about, where they allocate their funds, and what programs they offer. It just seems like there's going to be a lot of difficult decisions. I mean, is that a fair statement? I know that's not much of a question.
Yeah, I think so. I mean, and I also agree with Mr. Wilson on the fact that, making a once in a generation type distribution substation investment like they did, that's a significant increase in and of itself. But that is precisely the investment that I had in mind when I said, you should have approached us and came to talk to us about an alternative rate making mechanism, right? And maybe some of it is timing, in that it's unfortunate that we reduced rates in that 21 docket, because ultimately the company's net plant for growth related investments declined between rate cases. And then just 6 months later, boom, $20 million worth of investment hit. So that's another interesting question of, I was involved in that rate case. I never heard anything about the fact that, 6 months from now, we're going to do a $20 million investment. I think it would have been possible. We would have had to have requested the commission revise the previous settlement agreement. But for me personally, it would have been preferred. I would have preferred to have revised that settlement agreement that set the terms of the abbreviated rate case to say, let's extend this out one more year. Right? It's just not in anyone's interest to have that kind of volatility of rates. The math at the time supported that we needed to reduce the rates $650,000. But if at any point in that time, somebody would have said, but 6 months from now, it's really going to need to go up by 2 million. We would have been willing to have another conversation about a way to find a way to allow that to happen. Those are the kind of things that, that just never happened. So we are where we are today, and we sit here in a situation where they are going to have rates that are considerably higher than other utilities in the state. They are going to be in a position where they're going to increase customer rates 10% in the first year and then another 10% in the next year. We're probably getting pretty close to the point where this utility is just going to have to start to really grapple with the idea of it is a balance between affordability and reliability. And you can make power so reliable that nobody can afford it, and that's not a good thing. Maybe right after you make a once in a generation type distribution substation investment, you're just going to have to back off and recognize that we're going to have older distribution poles and maybe less reliable conductors in this town of Galena than we would have otherwise preferred, because we just increased customer rates by $27 a month. Those are going to be tough decisions. That's what the management of this utility gets paid to do. And we'll do our best to try to not make it any worse, basically, try to find ways to be creative in the rate making process and the company deserves credit too in terms of I think they are trying to do the right things. It's a good example is the alternative rate making mechanisms that are in the settlement agreement are a great example of the fact that, basically allowing construction work in progress on a generation investment that goes through a predetermination process, for instance, is a statutory right that utilities have today, as you know. But it doesn't make sense to go through a predetermination process for a utility with 10,000 customers who, their predominant regulator just approved that asset. So I just think that was a great sort of win-win example that can, that helps. And it's the sort of thing that, we encourage them to continue to think about. We'll continue to do our part as well. Do our best to regulate these, this utility for this subset of customers in an area of the state that is, historically has been pretty economically disadvantaged.
Well, we should end on that answer because that was a good summation of where we're at. But you piqued my interest because you mentioned the substation again. I'm just thinking through, potential ways that could have been treated. That's a sort of a poster child for a lumpy investment that gets completely allocated to a very small customer set. It's going to have a big impact, especially right at first before it starts depreciating. Do you recall, I think they said they were replacing a substation that was like 60 or 70 years old. Do you recall what the depreciation schedules were for the new substation? I know
No.
that's asking you a detailed question.
No, I don't.
Okay.
That's the sort of thing the parties could follow up on and put that in the record.
Yeah, my head is wondering if there is some, as you said, alternative rate making mechanisms. Maybe you can get creative with depreciation schedules. Obviously this one's already come, but strikes me that there are ways to handle these things. So, okay. I won't make you look up the depreciation schedules in the settlement. All right. I don't believe I have anything else. Commissioner Keen? Commissioner Keither, any redirect?
No, thank you.
All right. Well, with that, we thank you for your time and your testimony, Mr. Grady, and you may step down.
Thank you.
All right. Before we conclude, are there any final conclusory matters the parties wish to address before we adjourn? All right, seeing none. This concludes our hearing in docket number 26 EPDE 0180 RTS. The commission order in this docket is due by August 28th, 2026. If there are no further matters, we are, do you have
The settlement indicates that the new rates would go into effect on August 1st, 2026, so that would require an order prior to the August 28th date, but because parties aren't filing briefs and you don't have to decide litigation issues, hopefully that builds into the schedule the ability for the commission to issue an order so that the new rates can go in effect based upon what the parties agreed to August 1st.
Noted. I got carried away reading my script, but I'll give my standard spiel, which is we understand rates have been requested by August 1st. And even though our deadline is not until August 28th, we will make every endeavor to issue a decision before the requested date.
Thank you. And thank you today for the hearing.
Thank you.
Appreciate it.
All right. If there are no further matters, we are now adjourned. Thank you.